Good morning, ladies and gentlemen. Welcome to our panel members and to all of you joining us online today. Thank you for being with us this morning. My name is Gillian Lum. I'm a director in the employment law practice of Cliff Decker Hoffman. I'm based in our Cape Town office, and I'll be facilitating this morning's discussion. Our webinar this morning in our series of ongoing CDH employment law set webinars is focused on Zimbabwean exemption permits. As we all know now, on the 7th of June, the Minister of Home Affairs, having previously advised that there would be no further extension of ZEPs, announced an extension of ZEPs for a further 6 months until 31 December 2023. Given this development, it's opportune to discuss what you need to know about ZEPs, both from a legal and a practical perspective. The importance and significant impact of ZEPs on so many people living in South Africa, including a large number of employers, is borne out by the response we had to our invitation to this webinar. I'm very pleased to introduce our esteemed panel this morning, which comprises of two of my colleagues, Patini, who's a director in our employment law practice based in Johannesburg, and Taryn, an associate in our Johannesburg office, also in our employment law team, and Taryn specializes specifically in immigration law. And Patini and Taryn are joined by Nicole Fritz, an external speaker who's the executive director of the Helen Suzman Foundation. This foundation is a non-governmental organization which promotes South Africa's commitments to democracy, constitutionalism, the rule of law, and human rights. Nicole previously served as the Executive Officer of Freedom Under Law and founded and directed the Southern African Litigation Centre for a decade. She's participated in several global initiatives relating to international human rights law, humanitarian law, and public interest litigation. Nicole has also taught courses relating to these subjects in both South Africa and the United States and contributes public comment on these topics. Our panel is well placed then to advise in relation to both the legalities and practicalities associated with ZEPs. If you have any questions along the way, please feel free to raise those in the chat. We'll either deal with them in the chat as we go along, or if we've got time at the end, we'll address those through further panel discussion. So if I can then turn to our panel members, and kicking off with you, Patini. As I've said earlier, we've got the extension now for a further 6 months until the end of the year. And that's in the context of a significant backlog that the department is facing with applications for visas, and also the minister having previously announced that there wouldn't be further extensions of the ZEPs. So I think if we can go back to basics and just talk about what the ZEP is, why they are ZEPs, and what the ZEP is designed to do.
Thanks, Gillian. So just from a background perspective, what started off as a dispensation of Zimbabwean project known as the DZP was initially introduced by the Department of Home Affairs in 2008. Well, there were discussions around it, but the actual granting of DZP permits started in 2009. This was prompted by an influx. There's been some commentary that it was associated with the recession, but from 2009, South Africa experienced quite an influx of asylum seekers from the SADC region, and most of the seekers were Zimbabwean nationals. At that point, there was an estimated 1.5 million undocumented Zimbabwean nationals in South Africa. This is in addition to those who were seeking asylum. So the department then introduces what was known as the DZP, which went on until 2014. After the expiry of the DZP, the department then introduced what then became known as the Zimbabwean Special Dispensation Permit, which is now the ZSP, which then expired or was valid until the end of 2017. Along the way, then the minister, obviously now being cognizant of the backlog as well as limited resources, there was quite an influx, as I had said, now needing help to process applications, visa and waiver applications. The minister then announced the introduction of what we now know as the ZEP. The objectives of the ZEP, this is also the DZP when it was initially introduced, was essentially to give legal status to Zimbabwean nationals who had fled economic and political instability from their country. In remarks made by the former Minister of Home Affairs, Minister Malusi Gigaba, in 2014, he said that the objectives of this DZP and what then became the ZEPs was to firstly regularize Zimbabweans living in South Africa. This means that they could now live, conduct business, as well as work in SA. Secondly, to curb their deportation, irrespective of their status, they could no longer be deported. Thirdly, to reduce pressure on the asylum seeker as well as the refugee regime. I did mention that there was an influx of asylum seekers from the SADC region. The Musina refugee reception alone was receiving well over 1,000 applications daily. So that was quite a lot. And when the DZP project was started, the department had actually sought around 148 million from National Treasury just to help with this process. And unfortunately, they were only granted 15 million. So you can tell that there was quite a gap in funding, as well as the ability to bring on more resources to help with the applications. Finally, the minister said that the purpose of the DZP was to provide amnesty to Zimbabweans who had obtained South African documents fraudulently. So this could be a passport or an ID. Practically, Zimbabwean nationals who were in possession of fraudulently obtained South African documents could bring these forward without consequences. So that's it from a background perspective.
Okay, thanks very much, Patini. So if you can just clarify then, so if someone is a holder currently of a ZEP, what does that entitle them to? What rights do they then have in South Africa?
So firstly, as a permit holder, you may not be arrested or ordered to depart or be detained for purposes of deportation. You may not be deported for any reason related to you not having a valid exemption certificate. So that is the actual immunity. Then thirdly, exemption permit holders can enter and leave South Africa. Finally, they should not be required to provide a valid exemption certificate or a letter authorizing their continued stay in South Africa when they're applying for a visa of any category as provided for in the Immigration Act.
And so what does that mean then in relation to working and studying in South Africa for holders of those ZEPs?
So that means that you continue without repercussions, irrespective of your status. So if you are illegally in South Africa, you would be covered by that exemption. You can conduct business, you can live, you can study in South Africa.
And as you've explained to us, I mean, this has had a long history. This is the extension that's just been granted now at the last minute on the 7th of June. How many extensions have we seen? What's the sort of background there? Over what period of time has this been going on now?
All right, so currently the ZEPs, just them alone, we've had 4 extensions. They were first set to expire at the end of December 2021. There was then an announcement extending them for a further period of 12 months. So that is January 2022 to December 2022. Then there was another extension, which then extended their validity for the period of 6 months, expiring this month. Initially, it was supposed to be the end of June 2023. However, as you said, in the beginning of this month, there was then a further extension to the end of December 2023. Obviously, this then built on the history of the ZEPs, which were initially the first batch of ZEPs were granted in 2009. They went on until the end of 2014. There was no extension of ZEPs. Instead, the department introduced what became known as the ZSP, the Special Dispensation Permit, which then went on until the end of December 2017. It was then succeeded by the current ZEPs with its extensions, obviously.
And this final extension now that's been granted by the minister, may not be a final extension, but the extension that has now been granted, the Government Gazette, I mean, can you give us some idea as to what the minister said in relation to the reasons or the reasons that have been given as to why that extension was granted?
All right, so a lot of the reason is related to the reasons that were given previously for the extension. The department has described this particular reason or set of circumstances as a significant development, being the influx of visa and waiver applications. According to what they've put out there, informal communication is daily, the VFS Global, which is a company that is assisting with the processing of waiver and visa applications, is receiving an excess of 1,000 applications daily, between 1,000 and 1,500. So that's quite a lot, considering that the DHA has always stated that it's got limited resources and funding available to deal with the large number of visa applications it's receiving. So essentially, it is to deal with the increase in visa applications as well as assist with the backlog from previous applications. They've also stated formally that more officials have been deployed from the office of the DG to assist with processing of these applications. There hasn't been any indication of whether or not the backlog will be cleared by the end of December. So as you said, previously, the department has said that no further extension, but when they look at the numbers that come in, an announcement is made that there would be a further extension.
Yeah, as you say, that's a sort of the backlog is something that everyone is very well aware of. And I think for any applications, much as just the ZEP, people who are applying for visas now, historically, we've appreciated there's a significant backlog. So I think then if we can, thanks, Bettini, if we can turn then to Taryn, and I think looking against that backdrop, just the significance of all of this, what it means for employers, looking at the South African workplaces, what the relevance of ZEPs is in the workplace.
I think just going on from what Bettini was saying, excuse me, the relevance of ZEPs to the workplace is effectively that any holder of a ZEP can legally work in South Africa. And I think unlike some of the other visas that we have in terms of the Immigration Act, they're not limited to which employer they can work for and what position they can work in as well. So that would be the relevance of the ZEPs at the moment.
Okay. And so the employees, you say they can carry on working and they don't need to have specific visas, a work visa or a study visa. They can simply do that under the ZEP.
Yes, the ZEP allows them to continue working. So just like any other employee or any other foreign national with a valid work visa, they can continue to work until the 31st of December.
And looking at this period now that's been given a further grace until the end of the year, what is the intention then in relation to those people who do hold ZEPs? Presumably they should be looking at other visas or other sort of, how do they remain in this country if the ZEPs are not extended? Can you just talk to something about that and about the alternative visas that people could potentially be applying for then?
Sure. So I think one of the benefits of this extension, it's once again another opportunity for ZEP holders to try and obtain an alternative mainstream visa in terms of the Immigration Act. And when we look at alternative mainstream visas, we look at either your general work visa, which could be granted for a period of up to 5 years. We look at your critical skills visa that can also be granted for a period of up to 5 years. ZEP holders can also consider applying for a spousal visa or a relatives visa. And then they can also consider applying for a study visa, which would still allow them to work in South Africa, but there would be a limitation on the number of hours they'd be allowed to work per week, which is capped at 20 hours per week currently. So the extension will allow them to at least try and see whether they meet the minimum requirements of these alternative visas. And if they do, then to apply for these visas as well.
And Taryn, I know this is quite a tricky question to answer, but with your experience, if someone was applying now for a visa, what is the probability that they would get that visa, a response to that visa, an outcome of that visa within the next 6 months?
That is a tough one, Gillian. But just based on my experience, it's very unlikely that if you haven't already applied for a visa now, and if you did apply for a visa, that you'd receive the outcome by the 31st of December because of this backlog that the Department of Home Affairs has consistently been experiencing.
And then if it comes to applying for a visa, can you apply for that visa? ZEP holders, can they apply for those within South Africa, or are they required to travel outside of the country to make that application?
Fortunately, they can apply while they're in South Africa, because of the special dispensation.
And if one was then applying now and one got the outcome, or you've already applied, you get the outcome of your visa application and you're not successful and you're on a ZEP, would that mean that you're now required to leave the country immediately, or could you wait then until the end of the year when the ZEP expires?
So you're still legally allowed to work and live in South Africa until the 31st of December. So even if your application is unsuccessful, you can still work until that time. That'll also give you enough time to apply for an appeal against the outcome of your visa, depending on the reasons why it was rejected. So they would not need to leave immediately, no.
Okay. And then if someone's applying and they do that timelessly, but they haven't yet got the outcome of their visa application by the expiration date, the 31st of December, what would their position then be?
So they wouldn't be allowed to continue working for the employer without a valid visa. So even if they were waiting for the outcome of their visa, unless the Director General of the Department of Home Affairs issues the directive allowing them to do so. What we've seen in the last few years, because of the backlog at the Department of Home Affairs, is that the Director General has issued various directives allowing foreign nationals with pending visa and waiver applications to continue working on their current status due to the backlog. So whether a similar directive will be issued after the 31st of December or just before that deadline, we'll have to wait and see and monitor those developments as well.
Okay. And then, Taryn, if we can just sort of bring it back to employers and what the role of an employer in all of this. Have you got any sort of tips or guidance to employers in relation to, if you've got ZEP holders in your employment, how you can potentially be assisting them at this point?
Sure. So there's a few ways that employers can assist their ZEP employees. And I think one of the starting points is to provide their ZEP holders with information. A lot of the ZEP holders don't really know what alternative visas they can apply for in South Africa and what they may even qualify for. So as a starting point, it would be useful to sort of get a specialist in, obtain their services, and provide the ZEP holders with information. And another thing that employers can do is provide their ZEP holders with any supporting documents that they need in order to submit their applications. So these documents could include their employment contracts, their reference letters in support of their applications. It would include the letters of undertaking to the Department of Home Affairs as well. And employers can also consider providing their ZEP holders with some form of financial assistance in order for them to submit their applications or be able to afford to submit their application, as well as maybe some time off to submit their actual applications at VFF as well.
And Taryn, if we look sort of forward and we get to the end of the year, if there's not a further extension, what is the obligation then of an employer of a ZEP holder at that point?
So if there are no further extensions, I think from an employer's obligation point of view, in terms of the Immigration Act, you're not legally allowed to employ someone without a valid work visa or permit. So if it comes a time where the ZEP holder is not in possession of an extended ZEP or an alternative visa, employers would need to address their continued employment. But what's worth mentioning is that just because the ZEP holder no longer has a permit or an alternative visa, they still are defined as an employee in terms of the Labour Relations Act, as well as the Basic Conditions of Employment Act, and they still have the right to fair labour practices. So employers would still need to follow a fair process in order to address the continuation of the employment and also have a fair reason to terminate the employment at that stage. So when we consider an expired work visa, for example, or an employee not being able to obtain an alternative work visa, the process that we look to initiate is an incapacity process. So employers would need to bear in mind closer to the expiry of the ZEPs whether or not they would need to determine which of their employees have obtained alternative visas or not, and then take steps to address their continued employment.
So effectively you're saying, I mean, in this instance, the Immigration Act is effectively trumped to some extent by the Labour Relations Act. So it wouldn't mean automatically you simply deported and there are no rights in respect of a process and a fair reason for termination then.
100%. You still need to follow a fair process and have a fair reason as well.
And Taryn, just looking at the obligations of the employer again, as to to what extent you've got to investigate or interrogate whether people have the relevant visas, what the repercussions may be for an employer if an individual is found, if an inspection's done and an individual is found not to have the relevant visas. Can you just talk briefly about what the repercussions and obligations of an employer are again in that regard?
And I think if I maybe start with the threshold of an employer's obligation before employing a foreign national. So all employers need to make a good faith effort to ensure that all foreign nationals that are employed by them are in possession of a valid work visa and passport that would authorize them legally to work for that employer. And where an employer employs someone in contravention of the Immigration Act, they can then get arrested. So they'd be liable for a fine or imprisonment upon conviction. And what we are noticing is that from employers, people that are getting arrested, you look at your chief executive officer or your human resources manager or anyone within your human resources department that would have access to information regarding the employment of foreign nationals.
Thanks very much, Taryn. If we can then turn to you, Nicole. I mean, I think quite importantly for our audience is also to understand the legal challenges that have been going on in the background since June of last year, as I understand, when the foundation brought its application before the High Court in Pretoria, citing both the Minister of Home Affairs and the Director General. I think it would be really beneficial for our audience if you can just explain to us or give us some idea as to the basis for the application and the crux of the foundation's argument before the High Court.
Sure. Good morning to all the participants. Yes, as you've said, the Helen Suzman Foundation was one of several parties that sought to challenge the termination of the Zimbabwe Exemption Permit. And the HSF's arguments before the court, which were heard only, unfortunately, and we can discuss why that was the case, but were only heard in April of this year. By the courts, but those arguments went to, in the first instance, that the decision was made without consulting persons holding the Zimbabwe exemption permits or the South African public at large. Persons holding ZEPs are entitled to be consulted, and that flows directly from Section 33 of our Constitution. That provision enshrines a right to fair government decision-making, and it is not reserved only for citizens. A consequence of the minister's failure to consult before he terminated the Zimbabwe exemption permit is that he was unaware of the impact that decision would have on the lives of Zimbabwe exemption permit holders and the South African public at large. That inability to take into account the impact of that decision is one which HSF renders additionally makes the decision the minister made an unlawful one. The second argument that we make before the court is that given the destructive effect of the ZEP's abrupt termination on the lives of the holders and their children in particular, the minister's decision unjustifiably limits their constitutional rights, so substantive rights, not just procedural rights. In particular, we argue that their rights to dignity, enshrined in Section 9 of the Constitution, and the requirement that is set out in Section 28, subsection 2 of the Constitution, that a child's best interests are of paramount importance in every matter concerning the child, are ones which have been unjustifiably abrogated. And so that, in a nutshell, are the two legs of the HSF's arguments before the court. As I said, HSF was one of several parties. So in the HSF application, you had the Consortium of Refugees and Migrants also coming in as amicus, sorry, actually as an intervening party. So making arguments that were very much in line with those made by the HSF. And then there was a separate application brought by the Zimbabwe Immigration Federation, again, very similar to the arguments made by HSF, seeking similar relief. And then there was one brought by the Zimbabwe Exemption Permit Holders Association that seeks more expansive relief. Judging by the court's reception, we'll have to see whether that application, is granted. I mean, we haven't had judgment, so at this point we don't know if any of the parties will be successful. Thanks,
Nicole. So, I mean, as you've highlighted, I mean, very important constitutional imperatives that are being upheld here, and and I understand that's obviously linked then with the foundation's objectives and what it seeks to promote. So it's not only Zimbabweans that are affected, but obviously this is a very important decision from a South African constitutional perspective. Just if we can go back then to your point about the delay. I mean, you brought the application in June, obviously anticipating that there may be June last year, sorry, that it may be coming to an end in June this year. Can you just talk a little bit about the delays then?
Sure. So yes, I mean, obviously recognizing that part of the hardship of this decision is the abruptness with which it was made, giving people very little time to plan for their lives, and essentially placing people in an impossible choice with the looming termination of the ZEP, either to remain in South Africa, but as undocumented migrants with all the vulnerability that attaches to that status, or to essentially have to return to a country that they left more than a decade ago. And as has already been discussed, I mean, the circumstances which prompted that leaving, that exile, was because of the huge economic and political turmoil that was being experienced in Zimbabwe. And to a large extent, Zimbabwe is a country unchanged from what it was when many of the great majority of the ZEP holders, in fact, left Zimbabwe. And so we had made every attempt to try, and when we brought this action, to try and secure the earliest possible court date, understanding and hoping that we would then get a court judgment as early as possible, and to some extent, hopefully try and offset kind of last-minute chaos and panic and uncertainty. But, at almost the 11th hour, there was then an attempt on the part of Operation Dudula and the Association of South African Truck Drivers to intervene in the matter. And in order to accommodate those intervention applications, the court dates were pushed out, and the matter was only heard in April. As I've already indicated, we don't have any judgment yet. Obviously, this most recent extension, to some extent, alleviates the urgency, the imminent urgency of a judgment, but only slightly. Obviously, huge numbers of ZEP holders and those who are impacted by this decision need certainty and time in order to plan for the repercussions of this.
Nicole, if I could just understand then the relief. I mean, going back to the relief that you're seeking. I mean, it's not you saying indefinitely ZEP should continue then.
No, that's not the relief. We don't believe that we would have the legal means to secure such relief. It's, political decision makers are, we believe, provided the circumstances are right, are empowered to bring to an end special exemption regimes of this type. But they must be done in a lawful fashion, following fair process, that there must be ample notice provided, that there must be proper, real consultation, meaningful consultation with the stakeholders, and particularly with those most severely impacted by a possible decision, and that there must be consideration given for the substantive rights at stake, and that rational, proper reason must be given for a decision to terminate. And so, we don't believe that we were in a position where we could ask for indefinite extension of the ZEPs. What we have asked for is, given the way in which the decision was so abruptly terminated, that that decision must be held to have been unlawful, that it must essentially be remitted to the minister for a fresh decision following a fair procedure, and that once that fair procedure has been followed and a decision has been made in accordance with that fair procedure, that there must be notice given, fair notice given once the decision is communicated, so that people have real opportunity to plan and make provision for that decision. I think there will be inevitable questions about what the length of time is of such a process, and we can't tell you what a fair, meaningful process is going to be But that we imagine if you are going to consult with ZEP individuals themselves and with other stakeholders in the South African society, if you are going to weigh that and the impact of that decision, that is going to take certainly a number of months to be weighed, for a decision then to be made, for that to be communicated. And another aspect of our relief was that once a decision is then taken and communicated, that persons have at least 12 months following such decision before it in fact takes effect.
Yes, Nicole, as you say, I mean, it's got massive ramifications for people in the sense that you've got, hundreds of thousands of Zimbabweans living in this country who have made their lives here effectively and have children who are born here, have lived nowhere else. There's schooling, there's studies, so as you say, how long that period is, but you've got to give a significant period for people to be able to reorganize their lives should that become a requirement going forward.
Exactly. And for, as you said, for people who have made their lives here for over a decade, who have children here, who in many cases know no other home, there has to be at a bare minimum a fair process that is afforded these persons, individuals. Yeah.
I think then it takes it neatly into sort of what if you can give us some idea of what the Minister and the Director General was saying in opposition as to what their case was. They did defend the matter as to what their sort of highlights of their opposition then. Well,
I'm probably not the best person to represent the Minister and the Director General's arguments. Over the course of the exchange of papers, the rationale for the decision has changed slightly. I think once it came to arguments before the courts, and I think recognizing the strength of our consultation argument, they have argued that the consultation, didn't necessarily have to happen ahead of the decision to terminate, and in fact, their appeal to individual Zimbabwe exemption permit holders to make applications for waivers and exemptions are individual processes where consultation can be undertaken. Our response to that is that is not the types of consultation that is envisaged by our constitution in terms of fair decision-making processes, and that whatever consultation requirements might be built into waiver processes do not cure the deficiencies and the absence of consultation in making a decision to terminate the ZEP, as the Minister did.
And so, Nicole, if we do, face a situation where the Minister's decision is upheld at the end of the year, the ZEPs are terminated. Can you just talk a little bit? We've heard what Taryn and Patini have had to say, but just, what sort of the road ahead is for then ZEP holders?
Yeah, I mean, as I've said, I think the road ahead is an incredibly catastrophic one. I think, if there is no extension, if we are unsuccessful in our court application, as I've said, most ZEP holders are going to face the impossible choice of either remaining in South Africa as undocumented migrants, and we know that there is enormous vulnerability that attaches to such a status, or they must return to Zimbabwe, which is virtually unchanged from the country that they left more than a decade ago. Particularly the economic circumstances have not improved for Zimbabweans. The circumstances which led to the outflow of so many Zimbabweans in 2007, 2008 was in the context of post-election violence in Zimbabwe. There is, I think that intensity of the violence that we were seeing during those years may have somewhat abated, but of course Zimbabwe is approaching another election, and again there are accounts of repression on the part of the government, meted out towards opposition. So politically and economically, it is not a country that is particularly changed from the one which they fled, and which, you know, the South African government recognized were circumstances which compelled the establishment of the special exemption regime. And, you know, obviously, whilst we very much hope, fervently hope that we will prevail in our court application, you know, if we don't, if there are no further extensions, you know, we certainly hope that there will be waivers and exemptions granted of the type that the Minister and officials in the Department of Home Affairs have indicated that they will be willing to grant. A number, you know, there's already been reference made to the huge backlogs that the Department of Home Affairs is facing. And so certainly there would be, you know, have to be a lot more resourcing of these systems by which waivers and exemptions are considered for there to be real relief, given the large numbers of individuals who will want to be making applications for waivers and exemptions if there is no exemption and if we are not successful in our court application.
And Nicole, the application, as you said, that was argued in April. I understand the other two applications were argued at the same time. Do you have any idea as to when, any indication from the bench as to when they may hand on a judgment?
Unfortunately not, no. So we understand, and you know, the court will be aware, given the news reports of the minister's decision to extend the permits until the end of December. We know that the lawyers for the minister have shared the government gazette announcing that extension with the court. And, you know, we are very concerned, obviously, to some extent, the imminent urgency has been somewhat abated, but we're very concerned that there be no suggestion that the court is not required to hand down judgment as soon as is possible, because, again, I think the more time that is afforded, you know, to some extent, the misery that, you know, potentially awaits so many ZEP holders is mitigated. So more time is really a gift here. And that's what we have been keen to underline and emphasize.
Absolutely. Thanks so much, Nicole. I think for those of you who'd like to review all of the papers, those court papers are all readily available on the Foundation's website. So if you'd like to look at those. But I think there've been quite a lot of questions coming through. I don't know if the panel have been able to look at those as they've been coming through, but I think if we can maybe have a look at some of them. Taryn, I don't know if you've seen some of them, I think relating specifically to practically in relation to visas. The first question, what if an employee has proof of application for a visa permit, but an extension or visa status has not been granted by the end of the year? On what grounds can the employer terminate the employment at that stage?
So that would be based on incapacity, Gillian, because they would no longer have the legal capacity to work in South Africa after the 31st of December. That is, of course, provided that the Director General of the Department of Home Affairs hasn't issued any further directives allowing pending visa and waiver application holders to work until they get for a certain period while they're waiting for their applications to be processed.
So importantly, as you say, it's not a misconduct issue, it's a capacity issue where legally one doesn't have the right to remain in the country and work in the country. And so you go through a process then and still having a hearing and an opportunity for the individual to make representations.
Yes, that's correct.
And then, Taryn, the next question is, and I think a lot of these are going to be directed at you in relation to sort of practicalities of visa applications, but someone querying here where someone has applied for a waiver, but the passport has expired, are they allowed to continue working?
So ordinarily, when you get a work visa, your work visa is linked to the duration of your passport. So I'm not sure if that person is querying if it's a ZEP holder that has applied for a work visa, or if it's a
Yes, they are. They're saying specifically a ZEP waiver. Yes.
Yes. So there's the passport will need to have been valid in order for the visa to be valid as well. Because in terms of the regulations, in terms of the Immigration Act, you have to be in possession of a valid passport at all times as well.
And then there's a query just as to whether this also applies to asylum seekers. What's the situation with asylum seekers then?
So this does not apply to asylum seekers. This specifically applies to all holders of ZEP, Zimbabwean Exemption Permits. Asylum seekers are dealt with a little bit differently.
And then a query, Nicole, just on if the application before the court, the High Court is unsuccessful, thoughts on the approach that the foundation may take at that point.
Yeah, I saw that too. We're going to have to consider the judgment, right? And there might be applications for leave to appeal on either side. So, if we're successful, it's, probable that the minister and the department will seek to appeal. And similarly, if we are unsuccessful, and, as I said, there are 4 parties that have brought these applications, there may be an application for leave to appeal, but that decision can only be made once we've had an opportunity to see the judgment and to make an informed decision. But yes, that is certainly a possibility.
As you say, it'll be obviously then dependent upon what the reasons are for the judgment as to whether there's scope for that. Yeah. And then, Taryn, a query again about termination if in the event that there's no extension granted by the end of the year, as to whether if you've got a contract of employment that says that employment is conditional upon the individual having the relevant permit or visa to work in South Africa, whether the employment could then automatically come to an end on the 31st of December.
So the position would be the same, Lillian, is you would need to follow a fair process. So you could use the contract of employment as a basis to terminate the employee's employment, but they must still be provided with a fair opportunity to make submissions in that regard as well.
Yeah, so it just keeps coming through that we've got a trumping here effectively of yes. The Labour Relations Act. So that fairness is always going to be there, regardless of whether someone has the legal status to be in the country or not.
100%.
And then just a query here on how one checks whether an individual has a fraudulent visa, because we were saying, and as Patini was highlighting earlier, just some of the reason for these exemptions was fraudulent visas issued to people originally, as to how one can go about, particularly as an employer, assessing whether someone or determining whether someone has a fraudulent visa.
So you can do it in one of 2 ways. You can either request a verification of the employee's visa directly from the Department of Home Affairs. And normally what that process entails is you sending an email request to the Department of Home Affairs by and attaching the supporting documents, so the employee's passport, their visa, as well as their consent for the verification. And there's also an option to verify the validity of a visa through using a private company, sort of like MIE verification services. So you follow the same process, but there is just a fee that's applicable when using MIE verification services. But both processes, either way, they do take a bit of time. So an employer should bear in mind that it could take a couple of weeks, it could take a couple of months to get the outcome of that visa verification.
Thank you. I think we've covered a lot of them are sort of on the same continuum in relation to the legal process if there's no extension at the end of the year. And unless any of the panel members saw other queries that have come up which we need to address, I think we've covered the sort of key aspects. It leaves it then for me to thank our panel members for their time and their valuable contribution this morning. We very much appreciate it, in particular to Nicole. Thank you for joining us. I think that's been incredibly valuable to all of us to get the insight from yourself as the person who deposed to the affidavits before the court, and obviously going through that process on behalf of the foundation. Thank you very much for your time this morning. And then finally to those of us who joined online, thank you for your time this morning. I hope that you found our session valuable, and we'll obviously keep you updated as and when we hear about the judgments coming out from the High Court. We will certainly keep you updated on developments. Thank you all very much.
Visions are desires that flicker between a wish and intent. They are carvings waiting for the artisan's hand. One who is consumed by purpose. One who can bring vision to fruition. Cliff Decker Hofmeyer, incorporating Kieti law from vision to fruition.